السيدة ناتالي أنسلنا هي نائبة مدير الشؤون الجنائية والعفو بمدينة فرنسا. الآن الكلمة نعطيها للسيد جيسيبي سيفيريني رئيس الغرفة الخامسة بمجلس الدولة الإيطالي. Oui, c'est pas toi. ما حدش. الكلمة نعطيها للسيد حجيف سنان مستشار بمحكمة استئناف بباكو بأذربيجان.
Dear ladies and gentlemen, dear colleagues and organizers, first of all, I would like to express my appreciation for invitation to the Minister of Justice and, of course, for opportunity to represent my country in such an important conference. I hope that this conference will be a good platform for the exchange of international experience in the field of administration of justice. It's known that without justice there is no rule of law, no human rights and no democracy. The independence and impartiality of the judiciary are fundamental to the rule of law. They are necessary for the separation of powers and confidence in the justice system as a whole. A large number of documents have been adopted in this area. Among them are such universal instruments as the Universal Declaration on Human Rights, the International Covenant on Civil and Political Rights, the UN Principles on the Independence of the Judiciary, adopted by the United Nations General Assembly, as well as the European Convention on Human Rights and accordingly the case law of European Court, European Chapter on the Statute of Judges, recommendations and resolutions of the Committee of Ministers and Parliamentary Assembly of Council of Europe. The importance of this issue is also acknowledged in the documents adopted by the special institutions of the Council of Europe, Consultative Council of European Judges, and the European Commission for the Efficiency of Justice, CEPEJ. These documents became a roadmap for us when we launched a fundamental judicial reform in close collaboration with the Council of Europe. Particular importance has been attached to the independence, impartiality, transparency, and accessibility of the judiciary. It is well known that special place in ensuring the independence of judiciary, particularly with regard to relations with the executive, takes the creation of an independent body of judicial self-governance, the majority of which ought to consist of judges. It is this principle on which the Judicial Legal Council of Azerbaijan Republic has been established. It consists of 15 members, 9 of whom are judges. All three branches of power are represented within the Council, as well as two parties of the process, the prosecutor's office and advocacy. It should be noted that the rights of non-judge members of the Council are somewhat limited with regard to the rights of judge members. This is especially true of disciplinary proceedings. A mixed composition of the Council has a number of benefits. It allows the other branches of the power to be in the course of all events and aware of problems of the judicial system. These rules out any possibility of corporate interests and thereby attach additional legitimacy to the judiciary. This approach is also supported by the CEPEJ opinion. Today, the competence of the Council in Azerbaijan includes all the issues concerning the judiciary. Particularly, its exclusive powers include the organization of the selection of judges, evaluation of their performance, career advancement, questions of liability and reward. At the same time, its powers are constantly expanding in the terms of the so-called institutional independence of judiciary. So far, 13 amendments have been made to the law on its status. Those, for example, in accordance with the last amendments, competences such as the prevention of external interference in the work of judges have been assigned to the Council. And an additional mechanism to ensure judicial independence has been created. In terms of independence of judiciary, as well as the enhancement of the confidence in court, the personality of the judge is of high importance. Attaching special importance to this factor, Azerbaijan has developed the most transparent system of selection of judges in collaboration with the Council of Europe. A new body was created specifically to conduct the selection of judges. The Judges Selection Committee, members of which are made up mostly of judges. The selection process is a multi-stage procedure that includes tests, written and oral examinations, long-term trainings locally and abroad with the participation of international judges and experts, as well as internship in courts. It should be noted that all candidates, and there have been over 1,000 past exams in one room, while the process is observed by multiple local and international observers and media. The questions are selected from data bank by a computer program. Answer sheets are checked and the results are announced on the spot in the presence of candidates themselves. For maximum transparency, examinations are broadcasted online over the internet. Thanks to this selection procedure, a new generation of judges has been brought up who already make up 60% of the judge corps. It should be noted that I'm also personally selected by this procedure. The Council of Europe and the European Union, having studied this experience, acknowledged it as an interesting model of best practice, and Azerbaijan is happy to share it. Now, 123 candidates are undergoing a new selection. This selection procedure is highly evaluated in the last CEPESH study. The Council of Europe documents also emphasize the need for financial independence of the judiciary. This is also important in terms of the relationship with the executive. In this regard, judges' salaries, as recommended, are fixed by our law. Moreover, despite the economic crisis, the salaries of judges in Azerbaijan are constantly being increased. As such, for the past 15 years, judges' wages have augmented by 40 times. In addition, given the negative trend of some countries to cut the salaries of judges, in 2015 it was legislatively banned to reduce the salaries of judges. The judiciary also has budgetary autonomy. Thus, according to the legislative amendments, judicial budgets should always be agreed with the Judicial Legal Council, and the Council's budget cannot be less than it was the previous year. Alongside these, over the last decade, courts' budget have increased by 25 times. The irremovability and inviolability of judges can also be mentioned among the guarantees of judicial independence, which we have enshrined in the Constitution. Guarantees in this field have also been legislatively stringent. As such, for a variety of court instances, a specific age limit has been set 66 and 68 years, and the discretion of change, it has been eliminated. Previously, judges were appointed for 5 or 10 years, depending on the court instance. Moreover, a probationary period of judges has been reduced from 5 to 3 years. The ability to form professional organizations is an important element of judges' internal independence. Judges' associations created in Azerbaijan, which recently formed the Union of Judges, actively participate in the legislative reform in the judicial field, make proposals, conduct trainings for judges and court clerks on their own, and organize social events. By the way, the Association of the Judges of General Jurisdiction is a full member of the International Association of Judges. The independence and impartiality of judges are the standard of judicial ethics. Public confidence in the process of administration of justice, which, as it is known, is a major component of democracy, depends on respecting these standards. In this regard, taking into account the documents of the Council of Europe and the UN Bangalore Principles, the Judicial Legal Council has developed and endorsed the Ethics Code of Judges' Conduct. This document has embodied in itself all the new ideas in this area. The basic idea of the code is to ensure that the judge avoids actions that may lead to use of his or her powers for personal interests, having preferences, interfering with the efficient work of the court, and negatively impacting the public perception of the judiciary integrity. It should be noted that the Judicial Legal Council, taking into account recommendations of the Council of Europe, has developed the most democratic procedure of bringing judges to disciplinary responsibility in order to secure the independence of judiciary. Thus, the disciplinary proceedings against the judge may be initiated only by Judicial Legal Council and may be conducted only by the member of council who is a judge. Moreover, only judge members of the Council can vote on that issue. The judge against whom the disciplinary proceedings are initiated has the right to use the service of lawyer or the judge colleague for protection, as well as to appeal the Council's decision to Supreme Court plenum. These reforms are already yielding results, hence the most impartial judge, which statistics show that Azerbaijan is moving in the right direction. Confidence in the courts is increasing. In comparison with 2000, the number of appeals of the courts has increased by 18 times. 95% of the civil and economic lawsuits are satisfied. Decisions in 84% of administrative cases are delivered in favor of individuals. The stability of final judgments is 98% in civil and economic cases and 90% in administrative and criminal cases. Only 4 and 5% of complaints are lodged with the Supreme Court, the highest cassation instance of the country. As one can see, a significant simplification of access to justice has led to a drastic increase in the number of cases at the courts. Reducing the workload cannot be achieved only by increasing the number of judges. In this regard, actions are being taken to introduce the extrajudicial settlement of civil cases, and therefore international experience in this field is being studied. A project on mediation has been launched with the European Union. Moreover, legislative amendments are made to simplify and complete the enforcement procedure. Alongside these, e-services will sustainably help to foster the judgments related to indisputable monetary and property claims, which make up 60% of the civil cases subject to the relevant international practice. It is very pleasing that the reforms have earned international praise. The CEPESH, for instance, has commended the scale and results of judicial reform, expansion of the judicial self-governance, implementation of ICT and transparency. At the end of the 2017, Azerbaijan was also awarded with the Council of Europe's prestigious The Crystal Scales of Justice Special Mention for the project Court Pulse, the Management Revolution. Along with that, while celebrating the 25th anniversary of the cooperation between the Azerbaijani government and the World Bank, the Progressive Justice Services and Modern Judicial Infrastructure project implemented in the justice system in our country was evaluated as the most successful and won the World Bank nomination on application of innovative methods of provide better service to citizens. Practice of Azerbaijan has already caused interest of various countries such as Russia, Latvia, Moldova, Belarus, Iran, Ukraine, etc. Dear ladies and gentlemen, in conclusion of my speech, I would like to note that it is very important to reform judiciary all over the world because, as stated in the well-known wisdom, all the rights secured to the citizens under the Constitution are worth nothing and mere babble, except guaranteed to them by an independent and virtuous judiciary. Thank you for your attention. Shukran.
شكرا للأستاذ سنان على عرضه.